Hi everyone, welcome to week 7, November 3rd, 2020, and we are going to speak about the updating or the coming changes in legislation with respect to medical assistance in dying. So you should have discussed medical assistance in dying at some point since you started your program, perhaps in various courses, but you likely are not as up to date on MAID as you think to be as you move towards becoming an RN. This week, we are focusing on two aspects with regard to MAID. Changes that are coming to MAID legislation and how you as an RN might be involved with MAID. In a democratic society like Canada, a society's laws change or come into being because of the will of the majority of the population. For example, same-sex marriage has been legal in Canada for many years, yet it is not acceptable in number of other countries. Before the MAID legislation, or Bill C-14, became law in Canada, MAID had a very long journey with both supporters and detractors arguing their sides. Everybody in Canadian society did not support MAID, but there was broad enough support to allow it to happen. In 2020, there continues to be broad support for MAID and also for an expansion of the law, so what is allowed under the current MAID legislation is in the process of being changed. As you know, the CNA is the national voice of registered nurses in Canada, but it is also a political organization in how it brings forward the views of Canadian nurses to politicians, both federally and provincially. Based on discussions with Canadian nurses, the CNA provided recommendations to the committee that was examining Bill C-14 before it became law. Other nursing voices included representatives from the Canadian Association of Advanced Practice Nurses and the Canadian Nurse Protective Society. The former, so CNPS, had a particular interest because nurse practitioners like myself are one of the two types of healthcare professionals who can be responsible for assisting a patient to die under this legislation. The CNPS looked at the proposed legislation from the perspective of a nurse's liability, whether an NP or not, and gave a nursing voice to what was important to include so that nurses could have some protection. MAID legislation has been in place in Quebec since December 10, 2015, but it was June 17, 2016 before MAID became legal for the rest of Canada. Bill C-14 is included as an appendix in the National Nursing Framework that the CNA, document 2017B, developed around MAID. The CNA document supplements the CNO document, 2018A document, regarding MAID that you were to read for this week, and you need to be aware of and practice within both. As usual, you will also need to adhere to the CNA 2017A Code of Ethics. It's important for you as nurses to understand the history and context of MAID, so I'm providing information about dates and statistics. I wouldn't, however, ask you for such specific information in the exam that is in the last class. I posted multiple documents on eClass, such as the interim and public consultation materials, for you to have as resources. I won't be going through any of these documents in detail, but you should read them. I will only highlight some points to help you be up to date with where MAID stands in Canada. The last federal interim report covered January 1st to October the 31st, 2018, and annual reports were to start in the spring of this year. But of course, Canada had other issues to deal with during this pandemic. Since MAID started in Canada, there have been 6,749 MAID deaths, and there have been people who were denied MAID because of competency issues at the time, even though they had made the decision for MAID when they were competent. As you remember, the case from last year of a woman who underwent MAID a few months earlier than she might have needed to because she was worried that she would be denied it as her condition deteriorated. A Quebec Superior Court judge, Christine Bedouen, ruled in September 2019 that it is unconstitutional to limit the right to a medically assisted death to those whose natural death is reasonably foreseeable. She then gave the federal government until March 11, 2020 to drop that provision from the law. The federal government did not appeal her ruling, but chose to undertake public consultations before making any amendments. Consultations were online from January the 13th to the 27th, 2020. Over 300,000 questionnaires were submitted. Overwhelmingly, 73.1% of respondents reported that current safeguards would protect against the misuse or abuse of MAID if eligibility was broadened to people whose deaths were not reasonable or not reasonably foreseeable. Close to 80% approved of MAID for eligible and approved people who lost the capacity to make healthcare decisions before MAID was actually carried out, and for those who had prepared an advance directive. Because of the COVID-19 pandemic, the federal government's response has been delayed, and this past June, the Quebec Superior Court gave the federal government until November 2020 to make the change. So by the time you are an RN, then you might find yourself working with a patient who is no longer competent, but who has been approved for MAID while still competent. You need to understand that their lack of competence at the actual time of MAID will no longer be a legal issue. As long as they were competent when they were approved, then their decision will stand. So this slide is very important. It's conscientious objection with regard to MAID. Nurses, like other healthcare professionals and people in general, can be morally opposed to multiple things. For example, war, abortion, euthanasia, blood transfusions. And nurses in Canada have a right to follow their conscience as long as they do not abandon anyone in need of nursing care. As an RN, you may not be prepared to participate in MAID because you have moral or religious objections, or you believe that participating in MAID would pose too great a legal or professional risk for you. Nurses do have a legal right to object to being involved with MAID, as the law does not compel an individual to provide or assist with MAID. However, nurses also have a pre-existing legal duty of care to patients, which means that you must not abandon your patients. This legal duty of care means that you may need to safely transfer care of your patient to another healthcare provider who can address the patient's needs, so you do not prevent someone from getting the information and assistance that they want. The Ontario Court of Appeal wrote a judgment in 2019 that required physicians to give referrals for legal medical services such as MAID. The decision was unanimous and specifically noted that failure to make such referrals could lead to inequitable access to health care. It seems reasonable to assume that MPs would be held to the same standard. They also noted that physicians should carefully choose their area of practice if they have objections to certain services. Can you see the similarity with how, as an RN, you need to know your own values and not choose to work in a setting where those values would likely conflict with available patient care services? When you are working, you must ensure equitable care to your patients. And so if you object to taking or talking with a patient about MAID, let alone participating in the provision of MAID, then you also need to know the steps to take if your patient raises the issue of MAID. You may need to safely transfer the care to another healthcare provider, but always within the context of not abandoning your patient. You need to be clear about what you are willing to do and not do as an RN even before you start practicing. When you're thinking about where you want to work after graduation, you need to consider your own values and beliefs because you don't want to end up in a setting and have your values and beliefs compromised. So during the interview process for a nursing position, you have a moral responsibility to let your prospective employer know if you are conscientiously opposed to specific practices and procedures that are likely to occur in that workplace, especially if your conflict of conscience could affect the services provided by the prospective employer. In turn, employers are supposed to advise prospective employees about the services they provide that may be sensitive for some employees. Once you are working in a setting and become more knowledgeable about the common practices and procedures, then you need to anticipate and plan in advance if you realize that you could end up in situations of conflict with your conscience. We are focusing on MAID this week, but the same anticipation and planning is needed around any potential declaration of your conscious objection or your conscientious objection. You would then need to discuss with your manager or supervisor the types of care that are contrary to your own beliefs and values and request that your objection be accommodated unless it is an emergency situation. Remember that you cannot abandon your patient whether an emergency situation or not. Given the nature of the MAID process, it is unlikely that an emergency would arise with MAID, but you still need to talk with your manager so that they know to not assign you to a patient who is receiving MAID and that they will be open to changing your assignment for you if needed. For example, if a patient expresses their interest in MAID to you. If perhaps, even despite you planning ahead, you do find yourself caught in providing care that is in conflict with your conscience, then you need to immediately notify your supervisor. Declaring your conscientious objection and requesting accommodation is of course a serious matter that you should not take lightly. And though your employer should understand your position, it may not always be possible for them to accommodate you. Remember that you are not allowed to leave the patient until another nurse or healthcare provider is able to provide appropriate care to meet the patient's needs. So it is possible, though not as likely with MAID as it could be with other practices and procedures, that you may be required to provide some care that does not fit your values and beliefs because it is in the context of MAID. For example, imagine you are in a setting and a patient is scheduled for MAID, but the RN who was supposed to work with that patient that day is off sick and there's nobody else to replace you. There would be a possibility that if you could not arrange for a safe, continuous, and respectful transfer of care, that you could have to provide some aspects of MAID up to and including any of the roles that an RN may have in MAID. For example, making the patient comfortable before the procedure. Note that if you, as an RN, do not follow the legal requirements related to MAID, then you could find yourself being charged with a criminal offense and/or in trouble with CNO and facing consequences that could affect your registration. Trying to use your conscientious objection to claim that you didn't realize you were not following the requirements because you didn't know enough about the legislation, or 2, to claim that you could not be held accountable because MAID goes against your values and beliefs will not work. Conscientious objection is legal in regard to MAID, but you need to clearly understand the limits on what it allows you to do and not do. Let's look at the RN role prior to provision of MAID. As an RN, you must consider your professional standards, such as CNO and CNA requirements, and make sure that you meet those standards. The CNA 2017A document added multiple ethical responsibilities within their 7 ethical values that provide nurses with explicit information about what is expected of nurses with regard to MAID. In addition, RNs in each province and/or territory need to make sure that they follow their own regulatory body's requirements around MAID. Further, you must follow your employer's policies and practices, which could be even more restrictive than what you are legally allowed to do. Note that we're not focusing, oops, sorry. Note that we are focusing on the role of RNs, not the larger role that NPs may take in MAID. But you do need to understand the role of NPs and physicians in MAID so you can ensure that correct safeguards are in place for your patients and that you can be an advocate as needed. As an RN in Ontario, you will be able to provide your usual high-quality end-of-life nursing care to patients who are considering MAID. You also will be able to provide education and support to these patients and their families during the time they are considering MAID, when they make a decision one way or the other, and right up until and after MAID is actually provided. If you talk with a patient about MAID, you can do so only if the patient has initiated the discussion, and you need to provide objective information only. You must be really careful to ensure that you do not encourage the patient to choose MAID. Conversely, if you disagree with MAID, you are not allowed to impose your own views on patients, nor can you make judgmental comments about their choices. Note that if a patient asks you about MAID, you must clearly and carefully document the patient's request or desire to explore MAID, whether or not you have made a conscientious objection known to other. You have an obligation to collaborate with the healthcare team to ensure that the patient's request or desire is tended to, even if you have to pass on the information to another healthcare provider who can help. You also need to carefully document the information about MAID that you provided to a patient. So who obtains consent? The law requires that a patient or someone on their behalf and under their express direction makes a written request for MAID. This written request must be signed and dated before 2 independent witnesses, who also sign and date the request. The law lays out who would not be considered an independent witness and includes anyone directly involved in providing healthcare services or personal care to the patient. Therefore, as an RN providing care for a patient, you could not be a witness to their request for MAID. You may, however, sign a request for MAID on the client's behalf if you meet the legal requirements to do so, i.e., for example, you are over 18 years of age, you understand the nature of the request for MAID, you don't know or believe that you are a beneficiary under the patient's will, and you don't know or believe that you are a recipient in any way of a financial or other material benefit resulting from the patient's death. You can't determine a patient's eligibility for MAID or obtain a patient's consent as though those responsibilities lie only with the providing NP or physician. The NP or physician must obtain a written opinion from a second NP or physician that the patient meets the eligibility requirements. The providing NP or physician also must give the patient an opportunity to withdraw their request immediately before administering medication that will cause the patient's death or providing a prescription for a medication that the patient will self-administer. Provision of MAID, the RN role. Before agreeing to aiding with MAID, you need to verify that the legal conditions for MAID have been satisfied, and you need to be careful that you document your confirmation as well as the steps you took to make the verification. You may have been part of the patient's interprofessional MAID team, and so you would be aware of the process to date and that the conditions have been met. Nevertheless, you should review the patient's chart to make sure the documentation clearly shows that all the requirements have been met. In addition, you could ask the providing NP or physician directly. Note, too, that you need to document in the patient's chart that your aiding with MAID was performed under the direction and supervision of the providing NP or physician. As an RN and with an order, you will be able to prepare and insert the IV line that will be used for MAID. You also can prepare oral and IV medications. However, you are not allowed to administer any MAID prescribed medications. The providing NP or physician are the only healthcare practitioners who can administer MAID prescribed medications. You are not allowed to push such medications into a patient's IV line. Legally, patients can self-administer a medication to cause their death if it has been prescribed for MAID by an NP or physician. As an RN, you can't administer prescribed medications for MAID, but you can legally assist a patient to some extent in self-administration of oral medication that has been prescribed for MAID. The decision and the action of taking MAID medications must be the patient's. Be very careful though if you do provide assistance. All that you are allowed to do is pass the oral medication to the patient at their explicit request for assistance. You are not allowed to do anything that may be viewed as the actual administration of the medication, such as placing the oral medication in the patient's mouth or altering the medication to make it easier for the patient to swallow. So don't mix the medication with anything such as food or liquid. When a patient is actually about to receive MAID, you will still need to adhere to the professional standards, of course. Further, you must continue to follow your employer's policies and practices, which could be even more restrictive than what you are legally allowed to do. As an RN in Ontario, you will be able to provide your usual high-quality end-of-life nursing care to patients who are receiving MAID. You also will be able to provide education and support to patients and their families at this time. Support could include holistic interventions such as massage that meets the needs of the patient and family. After the patient's death, you will be able to provide your usual care to both the patient and their family. Respectful bereavement care, both short-term in the setting and then longer-term as allowed by your employer, should happen just as it would if the death had occurred in any other way. So we will have an opportunity to review any questions and have a full discussion on your requirements within MAID and the changes to legislation. And we will be meeting during a week 7 Zoom meeting on Tuesday, November 3rd from 3 to 4. See you then.